Hello friends, in the previous video I had given you 5 questions and their answers from commercial law. Now I am continuing with this commercial law and it is question number 6. Explain the rule of caveat emptor. Discuss the cases in which rule of caveat emptor is does not apply. The answer is the Latin phrase caveat emptor means let the buyers be aware, beware. It is a legal principle under Section 16 of the Sales of Goods Act 1930, which places the responsibility on the buyer to inspect and ensure the suitability of goods before purchase. The basic idea is that the buyer must use their own judgment and skill to assess the product. Generally, the seller is not responsible for defects unless they misrepresent or conceal them. In English common law, it was designed for traditional markets where buyers could inspect goods directly. The cases in which the rule of caveat emptor does not apply are exception to caveat emptor. Number one, fitness for the purpose. If the buyer knows the specific purpose for which the goods are required and relies on the seller's expertise, then the seller must ensure the goods are fit for the purpose. Example, buying a water pump for irrigation. If it fails to serve that purpose, the seller is liable. Second is merchantable quality. Goods sold by description must be of merchantable quality, that is, usable and free from hidden defects. Example, a packaged food item that is expired or contaminated violates this rule. Sale by description. If goods are sold based on description, that is, online or through catalog, they must match that description. Example, a phone advertised as having 28 GB storage must not have only 64 GB. Now, sale by sample. When goods are sold by sample, showing samples, the bulk material must correspond with the sample in quality. Example, if a fabric sample is soft and durable, the entire batch must be matching. Misrepresentation or fraud. If the seller misrepresents the product or conceals defects, the buyer can claim damages. Example, selling a car with a known engine fault without disclosing it. So this is misrepresentation or fraud. Now, sixth is implied conditions and warranties. Certain conditions are implied by law, especially in consumer contracts. Breach of these can override caveat emptor. Example, a warranty that a laptop will function for at least 1 year. Right. Question number 7. Explain the concept of conditions and warranties under the Sale of Goods Act 1930. The term condition and warranty under the Sale of Goods Act 1930 are defined and explained mainly in Section 12. Section 12.2. A condition is a stipulation essential to the main purpose of the contract. If breached, the buyer may treat the contract as terminated, can reject the goods and claim a refund. Section 12.3. A warranty is a stipulation collateral to the main purpose. If breached, the buyer can claim damages but cannot reject the goods or end the contract. Example, condition versus warranty. If a buyer orders a new car and it turns out to be used, it is a breach of condition. If the car is new but has a minor defect in the stereo, it is a breach of warranty. Question number 8. Discuss the rules relating to the transfer of property in goods under the Sales of Goods Act 1930. Answer is the rules for transfer of property in goods under the Sale of Goods Act 1930. It deals in Section 18 to 25. Section 18 says goods must be ascertained. Ownership of unascertained goods does not pass until the goods are identified and set aside for the buyer. Intention of parties. Section 19. Property passes when the parties intend it to pass, based on contract terms and conditions. Specific goods in deliverable state, Section 20. Ownership transfers at contract formation if goods are ready for delivery. Goods to be made deliverable, Section 21. Property passes only after seller completes necessary actions and informs buyer. Goods to be weighed measured, Section 22. Transfer occurs after such actions are done and buyer is notified. Unascertained goods, Section 23. Ownership passes when goods are unconditionally appropriated to the contract with mutual consent. Sale on approval, Section 24. Property passes when buyer approves or retains goods beyond the agreed time. Reservation of rights, Section 25. Seller may retain ownership until conditions like payment are fulfilled. Question number 9. Discuss dissolution of a firm. Explain consequences of dissolution. Answer is, as per Section 39 of the Indian Partnership Act 1932, dissolution of a firm means the termination of the partnership between all partners of the firm. Modes of dissolution: by agreement, mutual consent of partners, compulsory dissolution due to insolvency or unlawful business, on occurrence of certain events, expiry of term, completion of venture, death or insolvency. By notice, in case of partnership at will. By court order, on grounds like misconduct, incapacity, breach of agreement, etc. Now, what are the consequences? When the firm is dissolved, once a firm is dissolved, several legal and financial consequences follow. Winding up of business. All businesses operations cease. Assets are liquidated to pay off liabilities. Settlement of accounts. Debt to third parties are paid first, then loan from partners. Capital contribution are returned. Remaining surplus is distributed among partners. Liability of partners. Partners remain liable for acts done before dissolution. They may also be liable for post-dissolution acts if notice is not given. Return of premium. A partner who paid a premium for joining may get a refund if dissolution was not due to misconduct. Sale of goodwill, Section 55. Goodwill may be sold separately. Partners can compete but not use firm's name or solicit old customers. Notice to third parties. Public notice is essential to avoid future liabilities. In short, we can say dissolution marks the legal end of a partnership firm. It triggers a structured process of winding up, settling accounts, and discharging liabilities. Understanding these consequences ensures fair treatment of partners and creditors. Now, the last question, question number 10. Sharing of profit is only a prima facie evidence of partnership but not conclusive. Explain in the light of Cox versus Hickman case. And the answer will be, under the Indian Partnership Act 1932, sharing of profits is considered prima facie evidence of a partnership. However, it is not conclusive. The true test lies in the presence of mutual agency, where each partner has the authority to act on behalf of the firm and bind the firm by their actions. Cox and Hickman were business partners involved in a landmark English case, Cox versus Hickman, 1860, that helped define the legal concept of partnership. In this landmark case, initially Mr. Cox and Mr. Whitcroft were partners in a business that fell into financial trouble. To manage their debts, they transferred control of their business to trustees, including Mr. Hickman, under a deed of arrangement. These trustees were to run the business and use the profits to repay creditors. Some creditors who received profits from the business were later sued as if they were partners in the firm. The question was whether receiving profits made them legally liable as partners. Now, the decision of the House of Lords. The House of Lords held that receiving profit does not automatically make someone a partner. The true test is whether there is a mutual agency, that is, the power to act on behalf of the firm. Since the creditors had no control over the business and could not bind the firm by their actions, they were not partners. So, Cox was one of the original business owners and Hickman was one of the trustees appointed to manage the business. Their case became a cornerstone in partnership law, clarifying that profit sharing alone is not conclusive evidence of partnership. That's all about important question on commercial law. Please do subscribe my channel. Thanks for watching.